Morning, everybody. It's Kerry from RiskX. We'll just give it a couple minutes and just wait for people to sign in, and then we will start our presentation. Good morning, everybody. Welcome to our presentation on GDPR, the 12 steps the ICO recommends that you take. I'd like to introduce Steve Marshall, our resident GDPR guru. He's one of the senior partners in our business and knows everything about GDPR. Just some housekeeping. We'll have Pulse running in the background with polls running throughout. It's all totally anonymous. There'll be no recordings, and we'll also give you the opportunity to ask questions throughout. So you'll have a question screen, so just pop those down and we will answer them towards the end. And then after the presentation, we will send out a PDF version to you. So yeah, Steve, let's get started.
Thanks, Kerry. Morning, everybody. I realise you probably just said morning at your screen, and as I've muted you, I can't hear you. I'm just going to activate the pulse voting now. We're going to use this just so I can see how I'm doing as I go through, and whether the presentation is interesting, engaging, whether you want me to move forwards and those kind of things. What I've also got is just some very brief straw polls. The idea behind these is literally just to a bit of fun, really, in order to gauge where you are in your GDPR journey, and how engaged your execs are, and a bunch of other questions. And I'll pop these into the Pulse console as we go through. So I've literally just put the first question in now about where you are on your GDPR journey, and if you submit your feedback, we can have a look at those as we go forwards. So right, I'll get started. Why change the legislation? Well, interestingly, a lot of this is to do with data compromises in terms of data records and issues within the world as we've seen them today. As you know, you'll probably read a huge amount, in the press and on websites and these kind of things that suggest, more and more records are being compromised over time. And my slide shows basically the last 4 years, and as you can see, there's been a very large increase in terms of the number of records that have been compromised. I find all these things a little bit like snake oil in terms of, you get all this data and actually, what does it mean? I mean, there's a huge variety of information that's publicly available, and it suggests in 2016 anywhere between 1.6 and 3.1 billion records were compromised globally. Now I'm not actually sure that that's the case. There's a lot of territories and a lot of countries like the UK where breach reporting is not mandatory. at the current time. Therefore, actually, it could be an underreporting of records. We also can't tell whether these are unique records either, because it could actually be the same records being compromised on multiple different sites and multiple different locations. So it's very much the case that what it really shows is a trend, and it shows a trend towards, actually things are happening in the market, records are being compromised, and what we are seeing is that this is increasing. Legislation needs to catch up, and this is really about what the GDPR is doing in relation to this. It's looked at multiple different data protection legislations that exist within the European Union, and said, actually, the way the European Union works and the way that citizens move around and these kind of things, actually there needs to be a leveling off of rights and these kind of things. What we also see is that companies are blaming attacks as being sophisticated, and that they were victims of something that they had no way to protect themselves against. They couldn't have foreseen it happening. They take security seriously, and it wasn't really their fault, and there was nothing they could have done about it. Call me cynical, but we're a PFI investigator, and in the UK territory alone, we investigate about 70% of all the data compromises on credit cards within the UK at the current time. All the breaches that we see, I would say probably 99% of those breaches weren't sophisticated in any way, shape or form. They were very, very simple compromises. Somebody exploited an unpatched system, or they used a SQL injection, and what they did was they popped a web shell onto the machine and compromised it. So, what do we say? Patching. Most people hadn't patched. They weren't using any form of antivirus on their web servers, even if they were Linux devices. So actually, the web shell was never found. They weren't properly configured. They didn't know where their data was. They didn't know who had access or control. So actually, most of the things we see are really not that sophisticated. It's interesting. We saw, we've seen a number of things over time, and I was in a company the other day where I was working with them, and I was doing some social engineering of a government contractor, and I went in to see them and looked at their site. Said, "Oh, I've forgotten my pass. I'm the new director of audit. I can't get into my office. I'm going to get ripped terribly by my peers, and what do I do?" And the lovely little cleaner came up and said, "Okay, do you need to get through the door?" I said, "Yeah, that'd be lovely. Great. Can you help me out? Thanks very much." And she let me in. And it really is, in a lot of cases, this simple. You'll see from the next slide that we came across this one very recently. It's an electronic door lock, and what you'll actually see is that the numbers are worn on the keypad, and you can actually tell which buttons you need to press to get in. And if you look carefully, the numbers actually scratched into the top of the casing. The GDPR itself, very much, it was written by a German lawyer, and I met the lawyer that wrote this, and he said, "Yeah, it's very standardized and very efficient." I think the thing is that everybody tries to do the right thing when it comes to protecting customer data and looking at what happens and how to protect your customers, because ultimately they're your customers and they trust you with their data. Therefore, we all have the best intentions to get things right. However, other things seem to get in the way. Priorities for new services, stuff that makes more money or is more exciting. Let's be honest, right? It's more exciting to put new features into products and these kind of things than to talk about asset management or you know, protecting customer data or these kind of things. It's kind of not the sexiest IT topic that we're going to discuss. So compliance and regulation cost businesses money. Therefore, you know, it diverts attention away from their core business requirements. However, it's not going to go away. These things are, you know, becoming more and more and more pervasive, and a lot more legislation is coming. You know, we've seen it with standards like PCI, you know, being very granular against particular pieces of privacy information. We've seen, you know, POPI in South Africa come in, the King Report in South Africa. We've got the FCA in the UK that deal with financial institutions and these kind of things. Therefore, you know, there's going to be more and more legislation and regulation coming in, and sometimes businesses just need a nudge in order to make sure that they do the right things. And this is really what this is about. It's about tidying up all of these areas and making sure that customers know exactly what they need to do and exactly how they need to protect the privacy information of their customers. So I'm going to move on to the kind of nub. That was just a very general introduction. I see that everybody's fairly neutral against what I'm saying, and it's probably not engaging and those kind of things at the moment. Apologies for that. It's you know, just the introduction, and I'll get to the really exciting stuff of the GDPR regulations now. So what can you do about this? Well, the ICO has said that there are 12 areas that you need to look at today. So if you already comply with the Data Protection Act in the UK, or you have data protection processes in place, then what you'll find is that there are 12 key areas that they recommend that you look at today. These are awareness, information you hold, communication, individuals' rights, subject access requests, legal basis for processing, consent, children, data breach, protection by design, data protection officer, and international. And my plan is to go through each area of these, break them down for you so that you understand exactly what they are and what the ICO is looking for you to do at any point in time. So I'll start with the first one, which is awareness. And I'm going to stick the second poll up of today, which just asks you how engaged you think your exec are in terms of, are they engaged, are they not engaged? You know, how well do you think that they understand the GDPR as it is today? How do you think that they're going to react? Do they know what the requirements are? Do they know what the legislation says? Legislation is quite clear in terms of a lot of these things, and there are quite a few sanctions that are in place in terms of if you get this wrong. So you would have seen from one of my previous slides, there was a note on there that there's maximum fines of 20 million euros or 4% of global turnover. Now, there's other sanctions that are more important in terms of that. You know, the ICOs within the European Union, even if you're not domiciled within the European Union, if you're processing Europeans' data, you're still on the hook to make sure that actually your data protection is commensurate with the requirements, and that if you're doing widespread data processing, that you have a base within the European Union such that the ICO has the ability to be able to talk to you about your processing activities and these kind of things. Now, obviously, one of the things that everybody gets, you know, het up about is the monetary penalties. Well, yes, they're there. There are strict conditions in terms of their ability and their applicability. So one of the things that you know, you need to be aware of are there are set conditions within the GDPR as to when they can be used. However, there are other sanctions that can also be used, and some of these are actually more interesting in terms of the ICO can come in and audit you. They can do a containment audit. They can place undertakings on you. They can look at actually asking you to stop processing data. They can force you to stop processing data. They can decide that the data that you hold, you do not have the appropriate legal basis for processing or consent, and they can get you to delete it. They can force you to cease using particular processors that are not compliant or have had breaches. And actually, there's a huge amount of legislation that they can actually use in order to look at the way you process, how you process, and what you do. Okay, so those actually are possibly more onerous than necessarily the monetary penalty itself. Now, as per the DPA in the UK as it is today and the GDPR, there are no sanctions against directors directly, i.e. being able to put directors in jail in terms of what they do and how they do it and these kind of things for breaches of the Data Protection Act or breaches of the GDPR. However, one of the things that is specifically mentioned is that local legislation within each of the countries, there are a number of other legislations that can be used. So, for instance, within the UK, there are a number of things. I'll read some of them out to you. Criminal Justice and Immigration Act, Section 27, RIPA as it was, RIPA 2000 as it was now, which is, I believe, the Investigatory Powers Act, the Computer Misuse Act of 1990, the Fraud Act, the Bribery Act, and misconduct in public office. Now, they tell me that's a common law offence. Well, that's politics for you. So there are sanctions that can put directors in jail for getting this wrong, especially if it's a negligent breach. So those still do exist, but they'll be handled under other legislation, not directly under the GDPR itself. Now, when you start looking at all of the things that you need to do, I mean, the legislation is a lot more specific in terms of what's required from you, what you need to do and how you need to do it. Therefore, you're going to need executive support. They need to know what these regulations are. They need to know what they apply to and how they apply. You're also going to need their support in terms of time, money and resources. You know, it's very clear that any project that you're going to run or any program or works, and generally, you know, in a lot of companies, the larger the company, generally the more onerous and difficult it is. Some of you will have seen this from PCI programs and these kind of things, where you were only talking about one data element that forms one part of privacy information. Therefore, you know, this may be a lot bigger, especially if you've had, you know, lots of organic growth, taken on a number of different companies over the years, and you know, have data in multiple locations. So what I'm going to do is I'm going to move on to the next slide, which is about information you hold, and this is one of the things that you know, is interesting in terms of one of the things that you very much need to know, and is a one of the key things that people look at and the ICO specifically will want to know. So you'll hear lots of information about technology and lots of information from vendors and these kind of things that say, yeah, we can find all your data, we can tell you where all your personally identifiable information is within your environment, which is great. And ultimately, there will be some of that in terms of some of the tools that people will use and some of the things that you will need to do. Absolutely, you will need to find data. However, don't forget that the GDPR specifically makes reference to hard copy materials if they can be indexed, and it's very important that you know, you look at all of these things and say, right, okay, what does it actually mean? What is the personally identifiable information that I hold? Where is it? Where do I get it from? Who do I share it with? It's one of the things that you won't hear from a lot of these technology vendors about searching for data is actually about mapping your processes. One of the really key things to you is going to be to understand, actually, where do I acquire the data from? How does it come into my organization? Does it come in via email? Does it come in via file transfers? Does it come in via the website? Do people give it to me inside my retail shops? You know, where does it actually come from? Okay, so once I know that and I've got all the sources of those, where does it then go? Where does it go through my technology stack? Where are the people interacting with it? Where are they processing it? Where am I storing it? Where am I transferring it? And once I've mapped that, I then need to go into the process of actually, what third parties do I use? What third parties have access to that data excuse me, directly within my environment, but also what third parties do I share that data with? Now, this is going to become really important, and the reason I kind of make a big play on this is very much the case that this is one of the first things that you really need to understand well within your environment. The reason for this is, as we get through the rest of this presentation, what you'll see is things like legal basis for processing. You'll see about individuals' rights, and some of the rights the individuals have and the bases that you use for processing very much will dictate, how difficult it will be for you to comply with the regulations based on where you've got data and who you share it with. So these are going to be very, very critical things to you, and I can't stress enough the importance of looking at things like data audits, both from a process mapping point of view. So you'll need things like business process maps, but then you'll also need technical data flow maps, and you'll need things like data store definitions and data storage matrices and these kind of things, so that you can actually look at that. But then you'll also need things like third-party matrices and these kinds of tools and solutions in order to be able to show who you share data with, what that data is, and these kind of things. And you'll see that we'll come on to more of that. I know some of you are answering the polls. Thank you very much. I just put another one up in relation to do you know where all of your personally identifiable information is? So if people want to answer those polls, I'll leave that open for you for a minute or two before I move on to the next slide and look at communication. Now, one of the big things that has come up in terms of the ICO is they very much want companies to communicate with the data subjects. The reason for this is one of the big things that happens today under the Data Protection Act in the UK and in other data protection legislation is that companies don't communicate either clearly or effectively with their data subject in order to tell them what they're going to do with their data. Now, this is one of the major changes within the GDPR, is about communication, about the ease of communication and when you have to communicate. So what you'll see on this slide is that what you've got is a number of different things. Now, depending on whether you obtain the data directly or whether you obtain the data from a third-party company. Now, what this slide does is it lists all the things that you must communicate with the data subject if you acquire it directly from them, and also if you get that from a third party. So there are some interesting things on here. You have to identify the contact details of the controller or who's representing the controller in order to effectively own the data for processing. You have to tell them what purpose you're going to process and what the legal basis is, and we'll come on to legal bases in a minute because there is quite a lot of confusion around the difference between the legal basis for processing and consent as one of the legal bases for processing. What your legitimate interests are. So why are you interested in their data? What are you going to do with it? How are you going to process it? And all of these kinds of things. If you're going to transfer it to third countries, i.e. countries outside of the EEA and outside of data sharing agreements, so that would certainly include if you have US locations or you're US parented or you're within the African region or the Asian regions or these kind of things. Now, it's very interesting at the moment. The safe harbor was removed between the UK and the US and the EU and the US, and they brought in a new solution called EU-US Data Privacy Shield at the time. As some of you may know, there's a big battle running at the moment between Microsoft and Microsoft Ireland and the US government in terms of data sharing and the NSA gaining access to data. So one of the things that's happening at the moment is the ICO for the Republic of Ireland, Department of Search, has actually referred the case to the Central European Court for Justice and lodged a formal complaint that the EU-US Data Privacy Shield is illegal. So at the moment, there's a huge amount of confusion in terms of the requirements and what's going to need to happen in terms of data transfers to third countries and the safeguards. At the moment, what the GDPR says is that any data that is transferred to a third country needs to have protection that is commensurate with the standards of the GDPR itself. However, I would suspect that when we get down to it, at the end of the day, there's probably going to be a huge amount of legal challenge in terms of all of these areas. And until the first cases go through the European Courts of Justice or the European Courts of Human Rights, what we're not going to know is actually, is there any basis for transfers to third countries? And this is certainly going to affect companies that are domiciled outside of the European Union, and it's also going to affect them if they have no presence inside the European Union, but they do process data of European data subjects. Because actually, these rights belong to the data subjects. They don't apply to you as a controller or you as a processor or any of these kind of things. They apply to the individual. Therefore, even if you're domiciled in the US or in South Africa or other locations, the data belongs to the data subject, not to you as a controller. Therefore, the European Union have set this up such that actually, as those rights apply to the individual, you have to comply with them, even if you don't have processing or control facilities inside the EU itself. You also need to tell the data subjects what their rights are. You need to tell them they have the right to withdraw consent. We'll come on to what consent is and the other legal basis of processing shortly. You also have to tell them that they have the right to complain and that they have the right to lodge a formal complaint with either you or with their supervisory authority. And it's important that you tell them who these people are. Now, whereas before, data processors had very limited obligations under the Data Protection Act, specifically within the UK. The controller was on the hook if there was a breach. The data processor would only do what they were told to do by the controller if there was a data processing agreement in place between them. However, with the GDPR, this is not the case anymore. Data processors are absolutely on the hook, just as data controllers are. So what you'll find is that actually, just because you're an outsourced call center or you're a back office business processor, or one of these types of managed service provision companies, you're not off the hook if you are processing or storing or transmitting personally identifiable information on behalf of a data controller. Yes, there'll still need to be a data processing agreement. Yes, there will still need to be forms of obligations that are put into those data processing agreements. However, you are expected to know what the GDPR is, and you're expected to discuss that with the people that you get the data from, and you will need to know what legal bases they're using for processing of each of the data elements that you get, whether they're relying on consent or whether they're relying on higher orders of legal bases, and you'll need to know where the data originated from, so that if you are actually communicating on behalf of the controller with their customers, again, you have a responsibility to communicate with those data subjects and tell them either within a month or at the time of the communication where the data has come from and how it's been obtained. Now I'll move on to the individual rights. This is where it gets slightly more interesting, because the rights are actually upgraded in terms of data subjects and what they're allowed to do and what they can request you do as either a controller or a processor. Now, interestingly, a lot of this comes down to the legal basis that you use for processing and whether those rights apply or not. So, for instance, if you get a parking ticket or a speeding fine, no, you can't use the right to erasure on the local police force and tell them to delete your details because you don't fancy paying your fine. Obviously, somebody's thought about that and said, yeah, that's inappropriate, so you can't do those kind of things. So these individual rights are not absolute as far as the data subject is concerned, and they very much need to be proportionate and in line with the processing and in line with the legal bases that you use in order to process data for and on behalf of those subjects. So these are the upgraded rights, the individual rights that people have. The right to be informed, we've just talked about. That's about your communication with them and how you speak to them and what you tell them and when you tell them. The right of access, we'll talk about that on the next slide because that will form the basis for subject access requests, and I'll talk a little bit more about that in the next slide. The right to rectification. Now this is an interesting one. This is the right of the individual to be able to say, I want my data corrected, it's inaccurate. Okay, so if you hold data on people and they say to you, yeah, you've got my date of birth wrong, or you've got my address wrong, or you spelled my name incorrectly, you absolutely have to correct that, and it has to be done within a 30-day period. So this is going to be interesting in terms of lots of companies. So if you have multiple copies of the same data, the right of the individual means that you have to correct each and every single one of those copies. Additionally, you are also required to notify your third parties that hold the data. If you're the controller and they're the processor, you need to notify them because they have to rectify the data as well. Therefore, you need to tell them that they need to rectify it. Okay, so these are some of the things that companies are going to find difficult if their data is in multiple locations and they don't know where it is, or they've got multiple copies of the same data. This is why, when I started the presentation, I was talking a lot about mapping out your data flows, mapping out your data processes, understanding where your data is, and these kind of things. One of the things that the GDPR is really going to force you to do in reality is look at your data and look at where it is and how you've got it. And really, if you're a larger organization, you're going to need to look at things like, excuse me, I'll put my teeth back in, centralizing your data so that you have, single copies of the data and you're using primary sources for data. So if you're using copies elsewhere in order to run sales engines, or you're using it to run portals, or you're using it to run marketing campaigns or loyalty or these kind of things, you're going to need a central master data store that you can update, and then you need read-only copies in order to increase speed, availability, these kind of things when you're actually using the data within applications and in order to be able to provide customer support and these kind of things around other areas of your business. And it's the main reason for this is that even today, bear in mind that the GDPR doesn't come in until the 15th of May 2018. I've actually got customers ringing me up today and saying, yeah, I've had data subjects asking me to rectify my data under the GDPR already. I've got people asking me to erase their data or give me their data under data portability. And we're seeing quite a lot of this at the moment in that people are actually already starting to look at exercising their rights. Why? Well, I know I'm certainly going to do it. There's companies out there that, have annoyed me, have processed my data badly, have actually leaked my data and these kind of things. Absolutely. If I've got upgraded rights in terms of getting my data rectified or getting it erased, or actually getting them to give me my data back, yeah, I'm going to use it. I'm absolutely going to use it against customers. And companies that have not given me the best service and these kind of things. And you'll probably find it with some of your customers as well, which is why this is one of the key areas that the ICO highlights. You know, at the end of the day, if customers are going to use these things and you're going to fail to do them correctly, they will report it, because that's one of their rights. 7, the right to object. They have the right to object to either you not following the rules, you not being able to provide them with their data, or correct it, or give it back to them within the timescales that they've got. Therefore, they're going to report you. And ultimately, you know, if you can get the basics right, and the basics of these 12 areas that I'm covering today, the likelihood is that you'll be on a fairly safe playing field with the ICOs around the European Union, because actually you'll be able to show that you've done the right thing, that you're taking this seriously, that actually you can rectify data, or you can erase it, or you can restrict processing, or if people do object, that you have a process in place in order to be able to deal with it. So we'll come to the right to erasure. As I said, you know, the right to erasure is actually not an absolute right. So depending on the context, depends on whether you have to erase data or not. So I'll give you some examples of this. Okay, I'm a marketing company, and people have subscribed to me for marketing emails and marketing purposes. I have their consent, and they say to me, okay, I'd like you to erase my my details so that you know, you don't send me emails anymore. Okay, right to erasure, fantastic. I've got 30 days to comply with it. I can do that. I can remove their data. However, I'm actually allowed to keep enough data to ensure, one, that I can prove that I've complied. So I need evidence in order to be able to say, yes, they've asked me to erase at this point. I have erased their data. What I can also do is, if I'm an email marketing company, for instance, and I send emails to their email addresses, I actually am allowed to keep their email address in a suppression database in order to ensure that I don't email them again and breach their privacy and breach their request of me in order to do that. However, I don't need to keep their name, I don't need to keep their address or their date of birth or anything else in order to be able to suppress sending email to them. Okay, so I may only keep exactly what is required in order to comply with their request and in order to provide evidence that I have complied. Okay, so a lot of this is about communication, it's about record keeping, it's about telling people what you're doing and why you're doing it, communicating with them at the right time. Now, the right to erasure doesn't apply if they've used a different legal basis for processing. So for instance, if you're taking a credit card payment from them and you're providing them with a warranty service, for instance, they've bought a TV from you and it has a 3-year warranty on it, they've paid on credit card, they've formed a contract with you and they ask for their data to be erased, you absolutely have the right to object to that, and you absolutely have the right to say, no, we won't erase your data. Our legal basis for processing is contract. Therefore, we are obliged to keep your credit card and transactional data for, so for instance, in the UK, Visa requires us anywhere between 13 and 24 months for chargeback and proof purchases, depending on who your acquirer is. Therefore, you know, absolutely, you've got the right to say that data we have to keep. We're contractually and legally obliged to do so. Therefore, we'll be maintaining enough data in order to make sure that we comply with the rules. In order to provide the warranty and in order to prevent fraud, they've agreed that you may keep the data. Therefore, again, you have a legal basis for processing. It's a contract with the data subject. Therefore, you can keep the data. However, if they've given you consent in order to send them marketing or update emails, yes, you may have to remove that if that's their requirement under erasure. Restricting processing. Now, restricting processing is slightly like erasure, however, it's not permanent. So if somebody says to you, actually, yeah, I don't want my data erased, however, I don't want emails for the next 6 months because I'm going to be away, absolutely, that's something that either the data subject or you as a data controller or processor have the right to do. So rather than actually delete the individual, what they may want is a restriction in their processing for a period of time. And that's absolutely appropriate. And it's about communication between you and the data subject as to why you're going to restrict processing, or if they ask to restrict processing, so that both understand their rights, how long the restriction of processing is going to last, and what it means to each of the parties. Now, the right to data portability is an interesting one, and one that actually is has had some challenge already, and also there's some information from the Article 29 Working Party. Now, they're the group of ICOs and their representatives from around the European Union. They actually get together and look at all of these things and say, okay, you know, what do we need to do? Where do we need to provide clarification? Where do we need to provide examples and these kind of things? Now, right to data portability is going to be very interesting for a number of companies, and I'll give you a couple of examples in this area. So the first is an energy company. I'm an energy company. You know, I've formed a contract with you in order to buy electricity and gas off of you. Great. So you need a bunch of my details in order to be able to process. You need my name, where I'm going to live, my payment method, these kind of things in order to be able to do that. What you then do is you install a smart meter in my house to measure my energy consumption. Okay, fair enough. These things are, you know, becoming more and more pervasive these days, and you know, people want accurate bills rather than estimates. Okay, great, no problem. So out the back of those smart meters, a whole bunch of data is generated in terms of my usage. Now, who does that data belong to? Well, actually, it belongs to the data subject, because that data has been generated by their activities and by their actions. The fact that you have it as an energy company, okay, fine, no issues. However, if I get to the end of my contract and I want to move energy suppliers, I can absolutely ask for that data. And actually, as a data subject, I have the right to ask for that data, and you need to give it to me under my rights in the GDPR. Therefore, I can then take that data, I can go to a My Data website, go compare, or one of these types of sites, in order to put that data in, and it has to be an easy, machine-readable, common, open format. So something like a CSV file or text delimited files, or you know, these types of things, so they can be read in and understood by a machine, and you know, you can compare what you're getting from one company with what other companies will offer you, given the same data. Okay, now if the company does any analytics on that, provides you with graphs and these kind of things within your portal, no, they don't have to give you those, because actually that's generated from your data and that's proprietary to them, therefore that belongs to them. However, they do have to give you the raw data itself. As such, you know, this could become difficult for a lot of companies, especially if you're the likes of Microsoft or, you know, other big parties, because actually what you could say is, you provide my email service, that's my data, it falls under the GDPR, I've got 1 terabyte of storage within my email inbox, you need to give it to me, and you need to provide it in a format that I can use. And one of the things that's interesting about the GDPR is that it says you have to provide the data to the subject. No, you can't charge them for it, and you have to provide it in a format that they can easily use, which means if they have a narrow band connection, i.e., you know, they have a 56k dial-up to the internet and they've amassed a terabyte of data, and it's impractical for them to download it, you as the company have to supply it back to them on CDs, DVDs or hard drives, and no, you can't charge them for it. It is an obligation that you have to service and provide to that customer. This is one of the things that's specifically called out within the GDPR, and I think there's going to be a lot of legal challenge around this when people actually work out what the implications are. Again, you've got things like iPlayers and the likes of Spotify and these kind of things. If you collect the data about a data subject and it is about them, it's pertinent to them and belongs to them, so things like loyalty activity, purchase, spend, all of this kind of stuff, because it's about them, they have the right to ask for it and you have to provide it to them. I think this is going to be one of the big areas that the companies need to focus on. Right to object, we've talked about, you need to provide the details of who they object to internally of you, but also which data controller you're under, so they can make an objection if they choose to do so. Automated processing and decision making. This is a very big one in terms of lots of areas. Okay, if you're using processes like credit vetting or age verification or any of these types of services in order to make automated decisions about people, you need to tell them how they work. And what you can't do, and specifically the GDPR mentions, is you cannot hide behind intellectual property rights. If a customer asks, you have to tell them how it works. And no, you can't say it's intellectual property, I'm not going to give it up, because at that point they will have the right to object, and the likely as not you will lose. Okay, so you need to be very, very careful with that. You need to explain where automated decision making or profiling occurs, how that's controlled, how it is appropriate and fair and doesn't infringe their rights, and that they have the right to object to that for a human to actually look at the process and decide whether that was the appropriate or inappropriate decision. So all of these things are going to come up, and all of these things are going to be very, very important to you. Now, one of the things that I've talked to a lot of companies about is actually, if you're providing portals to people and you're providing access, a lot of these rights you can actually cover off with them directly by allowing them to do a lot of these things themselves. So a number of our customers and a number of the work that I've done with our customers is to say, right, create a portal, people create their accounts if they've got them already, you allow them to rectify their own data, you allow them to see the consents and what you've told them, when you've told them, so there's an audit log in there for them so they can see who they've spoken to, when they've given consent for different things, what that legal basis for processing happens to be, the fact that they can get at their data so you don't actually need to deal with subject access requests, they can deal with them themselves. You give them access to their data so that they can get their data out in common readable formats. And actually what you'll find is that if the data subject has the right to self-service, they will do a lot more of these things for themselves, and actually you'll get a lot less challenge and a lot less issues in terms of these things. Subject access requests, people want their data, they want to know what you hold about them. Yes, you have to verify who they are, because it would be a breach of GDPR for you to give personal data of somebody else to somebody that you haven't verified. You only have a month to respond, not 40 days as today. You can't charge for them either, so where people were charging a £10 fee and these kind of things, you can't do it anymore. However, what it does say is if claims are unfounded, they are vexatious in nature, or they're excessive, i.e. they become repetitive, or for instance somebody puts a website up that is derogatory about your company and incites people to make volumes of subject access requests against you such that they know that it will cause issue and problems within your company, absolutely you have the right to refuse at that point. You also have the right to respond but charge a reasonable fee. Now there's no set cap on that. What it means is, yeah, you can't charge the person £1 million for putting in a system to do the search to find all their data, but what you can do is you can reasonably charge for all of the administration time in order to pull all that data out, but you can only do that if the request is unfounded or excessive or vexatious in nature. If you do refuse, you have to explain why. As I said, you have 30 days to respond, although you can increase that by a further 2 months if the requests are complex or numerous, but you must communicate that within the first 30 days to the data subject themselves. Now, it's one of my pet areas, I have to say, is legal basis for processing. This gets confused significantly with what's called consent. Now, consent is, as you can see, one of the legal bases for processing. Now, a lot of people, and I was talking to some DPOs the other day, are looking to rely on consent. The problem with consent is that you can only use it if there's no disparity between the relationship of the controller and the data subject. Okay, so if, for instance, you're an online e-commerce store and people need to pay for goods, and the only opportunity that you've got to pay is with a credit card, there is no alternative, then there's already a disparity, which means consent is unlikely to be the legal basis that you would use for processing. Now, what I would say to you is, I'm not a lawyer, I'm an information security professional, and I specialize in a number of areas like privacy and PCI and these kind of things. So you will need some legal advice in this area. It's I know we all hate talking to solicitors and those kind of things, but unfortunately the GDPR kind of does make it hug a solicitor day when it comes to the legal basis for processing. What you need to do is, this is another reason to map out the data flows, where you collect, why you collect, and these kind of things, because what you will need to do is, for each of the pieces of data that you collect, you will need a legal basis for processing. And what you may find is that actually within one transaction you have multiple legal bases for processing that you need to tell people about, and you need to tell them and explain to them what that they actually are and what they mean. So consent's the lowest form. I'll come on to that in a moment. There's a slide on that next. Processing is necessary for the performance of contracts. This could be things like credit card processing, it could be a credit vet, it could be an address check, it could be an age check, it could be something like that. And you need to tell people that that is your legal basis for processing at the time you process the data. Processing for a legal obligation. One of these things could be anti-money laundering regulations, it could be know your customer regulations, it could be to comply with other legislation within your territory or environment, and you may well use that one. 61D and 61E are very much going to be used by the police and by local councils and these kind of things in order to carry out tasks that they need to do. The other one as a commercial organization that you'd be interested in is 61F, and that's legitimate interests. So for instance, if you are going to monitor the activities of your staff internally of your company, and actually you're going to monitor what they do with email, you're going to prevent them sending particular types of data out, or you're going to monitor the systems and look at what they're doing and look at things like their internet browsing and those kind of things, again, you are going to need to tell the data subjects that you have that work for you as part of your contracts or as part of your handbooks or these kind of things, that actually you can process their data, and it's based on 61F, which is legitimate business interests. And that's actually a very valid thing to do, and it's something that you know, is absolutely appropriate to you in order to do that. Now, consent, 61A. Consent is the lowest form of agreement, is the lowest form of legal basis for processing, and it is the one that the data subject has the most rights to challenge and has the most right to say, no, I want my data erased, I want to access and actually use these different rights that I have. Now with consent, generally most of those rights are absolute, which is why I suggest to you, one of the things that you'll absolutely need to do is look at higher forms of legal bases for processing. So contracts, legal requirement, legitimate business interest, because not all of those rights that the individual subjects have are then absolute, but they are with consent. Okay, so consent under the GDPR, no, you can't pre-opt people in anymore. No, you can't sneakily tick one box and untick another box. No, you can't use things where you trick them into ticking boxes because you use double negatives. Silence or inactivity does not constitute consent. So people actually have to do things. They call it unambiguous. So for processing normal categories of personal data, so things like credit cards, name, address, this kind of stuff, absolutely, you require unambiguous consent, i.e. they have to do something and they have to show you that they have understood what you've told them and have agreed. Okay. Now, if you're processing high-risk data, or you're processing special categories of data, so things like religious beliefs, sexual orientation, medical records, and other details that are, highly sensitive and would cause lots of damage, or a lot more damage if released, you need what's called explicit consent. And in those requirements, you need to go further than unambiguous consent. Unambiguous consent is telling people things, that giving them the option to agree or disagree, and then opting in. With explicit consent, you need them to do something. So you would need them to sign something. You can do that electronically, or there would need to be some form of, them writing that they agree into a box, or these kind of things, in order to show that they have absolutely taken definitive action that you can do those things. Consent and any form of legal basis for processing must be verifiable. You must keep records, and you must be able to show those if and when required. Now, it's one of the questions that get asked a lot. If you're relying on consent for things like email messages and marketing communications and all these kinds of things, the question then becomes, okay, so if I gathered them under previous data protection legislation, are they still valid? Well, the answer is yes, if you have the ability to be able to verify and show records that you've obtained consent that is in line with the EU GDPR requirements, that you have those records and that people understand their rights and those kind of things. If not, you will need to go back and reconsent those individuals, or you will need to delete the data. So those are very important. Now, one of the other big areas is children, and where services are offered directly to children, you must ensure that privacy notices are written clear, plain ways for children to be able to understand. Now, in the UK, we use something called the Gillick's competency test in order to look at the maturity of children and look at whether they are able to consent. Now, at the moment, children by the GDPR are considered age 16 and under, but it's an area that can be changed by each of the individual commissioners, and there will be some that will leave it at 16. There will some that will be able to change it. Now, the lowest they can put it down to is 13. The Information Commissioner in the UK has already indicated that they will likely reduce the age to 14, where children are considered underage and not able to consent for themselves. That's to line up with US legislation such that it's easy to exchange data with the US. Now, it's very clear that if you interact with children and you're providing particular services to them and those kind of things, you are likely to need parental consent. You're especially likely to need parental consent if you provide what they call information society services, where you're looking for remuneration, or you're doing direct marketing, or you're allowing them to create online profiles, or you're collecting data about in-app use or these kind of things. You will specifically need consent from a parent or guardian, and you will need to be able to show that consent clearly and effectively, and be able to provide that should you need to do so. Now, the next area is data breach. Now, I'm going to put up the next poll. Again, remember, all of these polls are anonymous. Okay, so we don't know who you are, we don't know who said what, We're just using them as a bit of fun in order to be able to look at these things as we go through the process. So data breaches are and will be notifiable. Okay, and a data breach they consider is anything that leads to the destruction, loss, alteration, unauthorized disclosure, access to personal data. Okay, so what they're saying is that if by your actions something happens and data is lost or stolen or altered or disclosed or destroyed without consent, then it could be a breach. Okay, and there are specific conditions and tests. Now, the Article 29 Working Party are providing more information in relation to this at the current time. Okay, and we'll probably run a specific, very short webinar on this in terms of what they say when that data comes out. Now, these are notifiable. You must notify within 72 hours. Do you need all of the information available at the time? No, you don't. What you do need to be able to do, though, is provide the reasons why you think there's been a breach, what you think has been compromised, what you think the likely damages are, and be able to provide a timeline in order to be able to show the information commissioners exactly what you're going to do and when you're going to do it. Okay. You need to know who your supervisory authorities are, and a lot of this depends on where you make decisions about processing and where you process data and where those data subjects are from. Okay. Breaches are likely to be notifiable by the ICO, so if a breach is confirmed and investigations done and findings provided back, it is likely that they will publish these publicly. Of companies, whether you are inside or outside of the union, and that is part of the legislation itself. They are also likely, depending on the breach type itself and the results of that breach, if there's a high risk to the rights and freedoms of individuals, they may well force you to notify those individuals as well. So a lot of this data breach notification is very much coming more towards what we see with the US and what we see with, protection of individuals' rights and notifying those individuals when they have been breached. And it is likely that there will be a slew of objections and complaints which may well force further activity by the ICOs and undertakings placed upon you. Now those, as I said, could be penalties, monetary penalties, there could be restrictions in processing, there could be a whole heap of other things that the ICO is allowed to do under their rights. Protection by design and by default. Now this is an interesting one in terms of what the ICO says and what they're allowed to do and these kind of things. What they expect is that you protect data by design and by the designs that you put in both your business processes and to the technology. Now, we hear a lot about data protection impact assessments, and these very much look at, what actually the implications are going to be and what the impacts will be to data privacy information when you make changes. Now, there are only two requirements that are covered. Using new technologies or the processing is likely to result in high risks for the rights and freedoms of individuals. Okay, well, great. So you're not going to use them very often formally. However, my advice to you is that actually you do use data protection impact assessments a lot. Whenever you make changes to anything, any of these business flows or any of these technologies, you use a data privacy impact assessment or a data protection impact assessment, but you have different versions. Okay, you have a heavyweight one that you use within your programs, so when you're making widespread changes to things like SAP systems or other big financial or customer databases, CRM, front ends, these kind of things, you use those then. But what you also do is use a light version of data privacy or data protection impact assessments when you're making changes to make sure that actually by your actions you don't expose privacy data to undue risk. So my view, yes, make sure all of your programs and all of your changes, so no matter whether they're small business changes, whether they're CapEx, whether they're OpEx, it doesn't matter. Make sure you know whether privacy information is going to be impacted or not within your environment. Now, what next, you ask? And that's a very good question. Data protection officers. Interestingly, data protection officer is a governed term, okay? If you're a public authority or you carry out large-scale systematic monitoring or process special categories of data, and some of those special categories are things like sexual orientation, things like religious beliefs, medical data, these kind of things, you have to appoint a data protection officer. But regardless of whether you appoint one or not, actually you're going to need somebody that knows about the GDPR and actually is a contact point within your company in order to do these things. Now, the interesting thing is that data protection officer is a governed term under the GDPR. There are specific tasks they're expected to do, but there are also specific employer duties that come with those. So the tasks are to inform and to advise, to monitor compliance with the GDPR, and to be the first point of contact for supervisory authorities. Now, one of the interesting things with a data protection officer is that they have to report to the highest level management. So if that's the board of directors within your organization, they must report for their data protection officer duties directly to the board level, okay, or a board member specifically, okay. They can't report to mid-level managers or these kind of things. They must operate independently. So one of the things that you're going to find is that actually this is likely to cause you some structural problems in terms of the way you set yourselves up as an organization and how you actually structure information security, but also things like legal and these kind of areas. Now, interestingly, one of the things that I've done with a number of companies is actually restructured and started to help them restructure and form things that we call business integrity departments. And business integrity basically is a function within legal, and normally you have a legal director on the board, and they're the highest point. Underneath them, you have independent functions within your organization, like information security, internal audit, revenue protection, legal, compliance, governance, all of these kind of functions that you need, that need ubiquitous reporting into boards. And this is ultimately where data protection officers will sit, is in that area, because they have to be independent. You can't fire them for doing their job either. So if they're acting as a data protection officer and they tell you something you don't like, you can't fire them for it, which is interesting. Yes, if they if they do something that constitutes gross misconduct, absolutely, that's an entirely different matter. But you can't fire them just for telling you things that you don't like. You must provide them adequate resources as well. So they must have access to staff, time, money, facilities in order to be able to do their job. And you can't restrict that. That's why it's very important to decide whether you are going to appoint a data protection officer or not. Now, I'm on to the last slides, so it won't be much longer now. Probably all fallen asleep. International. So international is about, okay, which supervisory authority do you actually fall under, and where should you process data, and who do you need to speak to about that? Now, a lot of this is about where you process data and who has autonomy. So, for instance, if I've got my head office in the UK, but actually all of my data processing is within Spain, so I have a call center in Spain, and actually they make all the decisions about how the data is processed, what happens with it, and those kind of things. The likelihood is that I would fall under the Spanish Information Commissioner's Office, not the UK. It gets much more complicated in terms of, understanding where these processes occur, if you're a multinational and those kind of things. And what you may well find is that actually, depending on where decisions are made about certain data, you may have multiple authorities that you report to. Okay, and this is going to be critical to you, because you have to actually tell data subjects which Information Commissioner's Office you're under and the contact details for it, so if they want to object, they can. Now what you have is you have something called lead and concerned supervisory authority. So for instance, if I'm in the UK and I process data in the UK, but I process a Spanish citizen's data and they decide to object, they can object to their local information commissioner, who then becomes a concerned supervisory authority, whereas actually the primary or controlling supervisory authority is the ICO in the UK, because that's where I'm based, that's where I process my data and make my decisions. Okay, so this is why, again, when you do your data maps and you look at where your third parties are domiciled, absolutely this is going to be important, because it will help you actually understand who is your information commissioner. Almost there. On the summary slide now, it'll pop up in a second into your screens. So what do we recommend? We've made two sets of recommendations here, some business recommendations and some IT recommendations. We recommend that you use management frameworks, okay, and align both your business processes and your IT processes. Now, we've looked at a lot of different frameworks and these kind of things for data privacy. What we found is that the main data privacy standard within the European Union at the moment is ISO 29100. When you actually read that, it talks about privacy information management systems and these kind of things. What it also says is that you can use ISO 27001 and just make sure that actually all your privacy information is relevant and is contained within there. Okay, make sure you can demonstrate compliance, because the burden of proof is upon you. Make sure you understand what your legal bases for processing are, and if you have questions about that, or want to look at different scenarios, I'm happy to help. But ultimately, you and your legal team will need to sign those off to make sure that you're happy with those. You need to be able to provide proof in everything you do, the communications that you have. You need to communicate clearly. You need to tell people what their rights are, what they have the right to do, what you are doing with their data, why you are doing it, and the reasons you hold it, the reasons you process it, and who you share it with. So some very quick examples. If you're an e-commerce company and you sell widgets, but you use a third-party courier company, you are going to need to share that data subject's data with the courier company in order for them to be able to deliver the widget. Well, you need to communicate with that data subject when they form the contract with you in order to purchase that widget, that not only will you be taking their data, you will be sharing it with potentially your payment service provider, your acquirer, and with a third-party courier company in order to be able to deliver their widget. And you must tell them in time for them to be able to make a decision and agree to that as a basis for forming a contract with you. Okay. Use codes of conduct. Certain industries, their trade bodies are forming codes of conduct around the GDPR at the moment. So if you're in a particular industry sector, speak to your trade bodies and associations and those kind of things, because they may well provide you with specific codes of conduct. You will need to map your data. You will need to find out who your third parties are. You will also need to find out whether your third parties have any third parties or third parties, because ultimately this is about trust chains and it's about contracts, and you need to be able to tell the data subject who you are sharing their data with. Okay, make sure that you align your IT with your business requirements, get the basics right, make sure that you can respond to incidents, make sure that you keep everything up to date so you're unlikely to have a breach. please make sure that you are able to be able to rectify data, correct data, be able to give them portability of data, make sure that you've got third-party technical controls in place, and these kinds of things. I'm going to put up some useful links. Presentation will be available at the end anyway. I'm going to stick the last poll up very quickly now to find out whether you found this useful and engaging, or whether that's an hour of your life that you'll never get back. So that's me done. So I'm going to hand back over to my team and deal with any questions and those kind of things if we have any.
Thank you very much, Steve. Does anybody have any questions that they'd like to ask? No?
If you do, you can type them in. What I'll also do is I'll actually unmute the audience, because we haven't got that many people on the presentation today. So if there are people out there and you want to ask questions, I've unmuted you so you can speak to me or the team and ask any questions that you've got.
Thanks, Steve. No, I don't think we've got anything.
No? Okay, fine.
What we'll do is thank you everybody for your time, and thank you, Steve, for your time. Jenny will send out the presentation as well as a link to the recording. If you've got any questions, Steve is available on email, so Jenny can provide you his details. And thank you again for your time.
Thanks all, and I'll stop the broadcast now.